So with the spread of the coronavirus, I wanted to put a video out just to talk about simple estate planning documents and things that you should be thinking about, at least for the immediate future until this passes. Now, your estate planning documents, if they're already done, then great. Just make sure that those documents are easily accessible to you and to family members for the next few weeks. And my suggestion would be that you put them in a location that's safe, but that is accessible. And just let somebody know, a family member know where they are. Now, if they're located in a safe deposit box at a bank, you might want to go get the original documents from the bank, because if for whatever reason the bank closes access to the public, then you may not be able to get access to your estate planning documents. And once again, once you get them, you want to put them in a safe location and just notify someone as to where they are. Now, what are those estate planning documents that you should make sure that you have so that, God forbid, something does happen, you're able or your family's able to handle the situation for you? When I usually talk to folks about their estate plan, I start off with a talk about their simple estate plan. And whenever I talk about the simple estate plan, there are three basic documents that everybody should have in place. Those three are the healthcare proxy, the power of attorney, and the will. Now, two of the three are only in existence while you're alive. So with the healthcare proxy, what you are doing, it's a legal document that appoints an agent on your behalf that will step in and make the decisions for you medically if you're not able to do so. And the job of the agent at that point would be to listen to the doctors and to administer your care in accordance with what the prognosis is, right? So the healthcare proxy is an agency, and it goes into place only when you're sick and only when you can't make your decisions medically. Now, if you get better, and when you get better, then your decisions will rule unless it's determined that you're not competent, and then your agent will step in. The second document that I always talk to folks about is the power of attorney. The power of attorney, we call it the durable power of attorney because it's durable in scope and durable in time. And it has a lot of general powers within it. This is a document, once again, it's a legal written document that you're going to sign where you appoint an agent to step in and take care of your assets, your money, your real estate, your investments, stock options, business options, okay, if you're not able to do so. What the difference is here is this is a document that's going to appoint an agent to take care of your stuff. So the first document we talked about was to take care of you, the person. The second document now we're talking about is the durable power of attorney. That's to take care of your stuff. And once you sign that document, it goes into place. You don't have to be incompetent, in other words, for that document to exist. And so with this document now, your agent can step into your shoes and do anything that you could do with your assets. So it's great in one sense where you could have someone actually step in and help you, but it could be dangerous on the other hand, right? Because it is durable, and if a person does have an original power of attorney, they can go do anything you could do. So you have to be careful with it. Once again, put it in a safe location. Now, those two documents are around while you're alive, while you're in existence. When you pass away, they terminate. Now, the next document I talk to folks about is when you're gone, and that is your will. That is a legal written document that's going to dispose of your assets at the time of your passing. And inside that document, you're once again going to appoint what we used to call an agent, right, or an executor. And now we call him a personal representative. And that person's going to step into your shoes as if you were still alive. So remember, you're gone, and this agent's going to step into your shoes as if you were still alive, pay off all the debts, and then administer or give out your assets the way you designate in that will. Now, with the will, this is only for assets that are in your name individually. They can't be held jointly, for instance, or they can't be an asset where you have a beneficiary that's appointed or designated, like an investment. These are for assets that are in your name individually. Now, why do I talk to you about all of these things? Well, folks, what the idea is here is that if you should get sick and you're still with us, your family will be able to step into your shoes, take care of you without running to the probate court and getting a judge's order. Because without these documents, your family will need a judge's order in order to take care of you and to take care of your stuff while you're still alive. And then the will, of course, is when you're gone, like we just talked about. So make sure these documents are accessible. Make sure that someone knows where they are, and stay safe. Dave Ceruolo, CeruoloLaw.com.